Good afternoon and welcome to our webinar, the second in the series exploring the life cycle of a contract. On the 25th of January, my colleagues explored the birth and infancy of a contract, and today we're looking at teenage problem years. Before we start the webinar, I should make you aware that to keep background noise down, we've placed each of you on mute. However, if you do have any questions, please use the chat function throughout the presentation and we'll pick these up at the end. We try to make this webinar as interactive as possible, so please do respond to our surveys and use the voting buttons when prompted, as though these show us there are still some people listening. I'm Guy Harvey, the Head of Commercial Disputes at Shepperton and Wedderburn, and I'm joined today by Douglas Campbell, a solicitor in the Commercial Disputes team in our London office. As disputes lawyers, the majority of our time is spent in reviewing and trying to repair instances where contracts have gone wrong. In addition, we often work closely with our colleagues in the Shepperton Wedderburn corporate department, dealing with problems in anticipation when complex contracts in niche areas are being drafted. This provides us with first-hand insight into how to plan and manage contracts through each stage of their life cycle. As I mentioned, this is the second webinar in a wider series on the life cycle of a contract. In the first webinar, we looked at the birth, or in other words, formation of a contract. Don't worry if you didn't manage to catch that. Today's webinar explores different issues that should be useful and accessible in any event. However, if you are interested in watching our earlier webinar on the birth of a contract, please do feel free to view it on YouTube using the link below. So, in today's webinar, we look at the teenage problem years in the life of a contract. Contracts, especially those which the parties anticipate will be in place for long periods, require management. Circumstances can change from those existing at the inception of the contract, and parties need to accommodate those changes. Today, we'll be looking at the legal issues that often arise in these circumstances. Later webinars in the cycle will look at divorce, when the honeymoon period is over and one party wants to terminate a contract by force. We'll look at what breaches of contract allow for termination. And our final session will be on death and estate planning, or in other words, how to plan for the demise of a contract. We've put the dates for the webinars on the screen just now. I do hope you'll be able to join us for them. There's obviously an infinite number of situations in which problems can occur in a contract, but today we'll address three areas where disagreements regularly arise. Firstly, a variation of contracts. Secondly, implying terms into contracts. And thirdly, restrictive contracts. And we'll illustrate some of the difficulties that can arise in these areas with three recent cases which are highlighted on the slide. As we go along, we'll highlight some practical tips in the focus areas, either emerging from case law or more generally. We hope these will be relevant for anyone involved in advising on contract law or entering into contracts on behalf of business.
So our first focus area is a variation of contract. Let's assume you have a contract in place with another party. It may be, for example, a long-term supply contract and you wish to vary one or more of its terms as time progresses and circumstances change. An example would be a long-term supply agreement where there's obviously a balance to be struck between agreeing favourable terms and a better price against exposure to risk in a changing market. Of course, if possible, you should think about including review clauses or break clauses from the outset. In the current economic climate, this may be even more prudent and possibly easier to agree than one might think, given the uncertainty as to whether the economy will improve or fall further. But if a contract does need to be varied, how do you do this? You could always agree to terminate the existing contract and create a new one. However, realistically, it's more usual and efficient to vary the relevant and specific terms of the existing contract. Whichever method the parties choose, the end result will be that a new contract is created. For this reason, you need two basic elements in order to vary a contract. The first requirement is consideration. As with the creation of a contract, both parties must give consideration for the variations. The courts define consideration very widely, and this was reviewed in our first webinar if you'd like further information on the topic. The second requirement is that the parties comply with any necessary formalities. There are two potential sources of formalities. Firstly, in certain situations, legislation might impose restrictions. Hence, if the original contract being varied is required by law to be in writing, then that contract can only be varied in writing. For example, Section 2 of the Law of Property Miscellaneous Provisions Act 1989 provides that all contracts for the sale of land must be in writing and signed by the parties. As a result, any variation of such a contract must also be in writing and signed by the parties. The second and more common source of potential formalities is the original contract itself, by which the parties can specify any conditions they want in relation to future variations. Additional requirements may apply if the parties wish to vary a term that impacts on a third party, such as a guarantee, but we'll stick to the basic elements today. In the absence of any required formalities, a contract can be varied easily, for example, orally or by conduct. This may not be attractive to parties who wish to avoid inadvertently or unwittingly varying a contract down the line. Therefore, in the original contract, some parties insist upon an express clause requiring any variation to the contract terms to be in writing. We'll call these anti-oral variation clauses. For our first area, we're going to consider the effectiveness of these anti-oral variation clauses. For some time, the law has been a little unclear in this area, as there are contrasting Court of Appeal judgments. In United Bank Limited against Masoud Asif in 2000, the Court of Appeal held that a contractual requirement for variations to a deed to be in writing and signed meant that no oral variation of the written terms could have any legal effect. In other words, an anti-oral variation clause was wholly effective. However, 2 years later, in World Online Telecom Limited against Iway, the Court of Appeal held that there was no direct authority on the question of whether the parties could prevent oral variations of a contract through the use of such a clause. The Court commented that the parties have made their own law by contracting and can in principle unmake or remake it. In other words, an anti-oral variation clause was not an effective clause because parties are free to vary the clause itself at the same time as any other variations. Hence, the Court considered that it is not possible to restrict this freedom in such a way. Let's now turn to our first case study. In April last year, Globe Motors Inc. against TRW Lucas, the Court of Appeal chose to address the conflicting case law and to clarify the position on anti-oral variation clauses. The facts of the case are as follows. TRW produced electric power-assisted steering systems. Globe Motors designed and manufactured electric motors and lead frame assemblies, a component part of the power steering systems. The parties had entered into a long-term exclusive supply agreement whereby TRW agreed to purchase products from Globe Motors and Globe Motors agreed to supply the certain product exclusively to TRW and not to third parties. As the contract progressed, TRW started purchasing certain products from another supplier. The Mercantile Court found that TRW was in breach of contract. TRW appealed this decision to the Court of Appeal. The Court of Appeal granted the appeal on close consideration of the scope of products encompassed by the agreement, but what was said about anti-oral variation clauses makes this appeal so interesting. The supply agreement was signed between Globe Motors Inc. and TRW. However, in bringing the claim against TRW, Globe contended that Globe Motors Portugal also had a right of action because the parties had acted as though Globe Motors was also a party to the contract. TRW argued that Globe Portugal did not have a right of action because the court required that any variation be in writing, and there had been no such variation making Globe Portugal a party. Specifically, the exclusive supply agreement contained a clause providing that this agreement, which includes the appendices hereto, is the only agreement between the parties relating to the subject matter hereof. It can only be amended by a written document which specifically refers to the provision of this agreement to be amended and is signed by both parties. TRW argued that this clause was effective and that the contract was not capable of variation orally or by conduct. Among the arguments they advanced, TRW stressed that the policy benefits of anti-oral variation clauses. Anti-oral variation clauses provide certainty and avoid false or frivolous claims of an oral agreement, For example, if there's a dispute and one party brings a claim, it's harder to obtain summary judgment if the other party can claim that it was varied orally. Anti-oral variation clauses can prevent a person in a large organisation producing a document which unwittingly and unintentionally was inconsistent with a provision in an existing contract. The tension lay in conflicting agreements between the parties. On the one hand, the parties had agreed that any changes to the contract have to be in writing, but on the other, they have subsequently agreed that the contract should be altered without following the stipulated process. Which agreement should prevail? So we're now going to open the first poll, and we'd ask that you use the voting buttons to respond to the question on your screen now. So, 85% of people said answer A, yes, the parties should be entitled to restrict the way in which future variations are made, and 15% said no, you should not be able to vary the future restrictions which are made orally or by conduct. The answer is B, so let's look at what the court said. The court considered that anti-oral variation clauses are ineffective. The decision came down to the overriding principle of freedom of contract. If you chose answer B, you agreed with the Court of Appeal in this case. The court said, the parties have freedom to agree whatever terms they choose to undertake and can do so in a document by word of mouth or by conduct. The consequence in this context is that in principle, the fact that the parties' contract contains a clause such as Article 6.3 does not prevent them from later making a new contract, varying the contract by an oral agreement or conduct. That may seem a bit frustrating, that the parties should not be able to insist that future variations are made in a particular way, especially because there does seem to be valid practical and policy reasons for this. If, for these reasons, you opted for answer A, note that the Court of Appeal did share your sympathy for this position. Lord Justice Underhill noted the policy points that TRW had advanced and expressed the hesitation he had in reaching his decision. In his words, it seems to me entirely legitimate that the parties to a formal written agreement should wish to insist that any subsequent variation should be agreed in writing as a protection against the raising of subsequent ill-founded allegations that its terms have been varied by oral agreement or by conduct. Even though ill-founded, such allegations may make the obligations under the contract more difficult to enforce, more obviously by making it more difficult to obtain summary judgment. However, despite the sympathy with certain policy grounds, freedom of contract was the overriding principle, and therefore the court considered that anti-oral variation clauses are unlikely to be effective. Just as parties should be free to agree that contracts should be in writing, they should also be free subsequently to reverse that agreement. This is not to say there is no value in anti-oral variation clauses, as the Court of Appeal noted in this case. For example, including them in a contract will make it hard for the party arguing in favour of a variation orally or by conduct to establish that variation. Although the views expressed are only obiter, this case confirms that the approach of the court in worldwide online telecom had significantly weakened the status of anti-oral variation clauses. Although the comments in this case were not the substantive basis of the judgment, the clarification it offers is likely to be highly persuasive, and indeed has already been followed in another case in 2016, MBW Business Exchange Centre against Rock Advertising. Therefore, it's important to understand the practical implications for parties who are either forming contracts or have existing contracts in place. So what practical lessons can we learn from this case? We have three suggestions. Firstly, be cautious about the protection that anti-oral variation clauses provide. While they retain value and they make it harder for the parties to vary contracts except in writing, they're not foolproof. Secondly, if you're part of a large company, ensure that your representatives are aware that their conduct or conversations with counterparties could potentially amend the terms of a contract, even if they don't mean to. Where parties are subject to a complicated contract, often negotiated by lawyers, it can be useful to have a contract guide setting out the key terms and effect to be circulated to the operation teams applying the contract day to day. Lastly, develop and comply with good change management processes to keep on top of all your company's contracts.
Thanks, Doug. Let's move now on to our second focus area in the teenage problem years of a contract. Difficulties may arise as a contract progresses. As a result of the change of circumstances, it's not unusual for one party to claim that the expressed terms of a contract do not adequately reflect the intention of the parties at the time of the creation of the contract. In this scenario, a court may be asked to apply terms into the contract to fill the alleged gaps in drafting. So let's recap on the basics of expressed and implied terms. Expressed terms of a contract, as the name suggests, are those terms that have been expressly stated by the parties either in writing or orally. Implied terms are therefore those that have not been expressly agreed by the parties but are implied into the contract by law or by the court. The court can imply a term into a contract on the basis of usage or custom. For example, a contract may be deemed to incorporate any terms which are customary to a particular trade. The court can imply a term into a contract on the basis of the parties' previous course of dealings. Where two parties have consistently conducted business in a certain way in their previous course of dealings, the court can imply a term relating to that course of dealings. But to do so, it must be shown that firstly it was the reasonable expectation of the parties that the term would apply to the transaction in question, and secondly, that the implied term does not itself conflict with an express term of the contract in question. The court may imply a term into the contract on the basis of common law. Common law, which terms are often referred to as characteristic terms, because the law sees them as a necessary characteristic of a particular type of contract. For example, it's an implied term of an arbitration agreement that the arbitration is confidential. The court may imply a term into a contract on the basis of statute. Terms are implied into various statutes and statutory instruments. For example, the Sale of Goods Act 1979 and the Consumer Rights Act 2015. The court may apply a term into a contract on the basis of the intention of the parties to fill a gap in the contract's drafting. This test is objective. The court will consider what a reasonable person would have understood the party's intention to be, given the background knowledge reasonably available to the parties at the time they entered into the contract. It's this final point on which we're going to focus today by looking at the important case of Marks and Spencer against BNP Paribas. There's been a long line of case law considering and developing the correct test for implying terms into a contract, in fact, to reflect the other party's intentions. Marks and Spencer against BNP, a Supreme Court case of December 2015, is the latest and significant development in this line of authorities. The facts of the case briefly are as follows. There were 4 individual commercial leases in which Marks and Spencer's was the tenant and BNP Paribas was the landlord. We'll call them the tenant and landlord for ease. The leases related to 4 floors of an office building at Paddington Basin in London. Rent was payable in advance under the terms of the lease. Shortly after paying the next period's rent, the tenant served a break notice and requested that the rent be apportioned and to account for the fact of the break notice. However, the lease did not contain an express term providing for such an account to be taken. The tenant claimed this was an implied term of the contract and the landlord should return the money. Specifically, the tenant asserted that the older, more stringent test to imply a term had been softened by the Privy Council in a case called the Attorney General of Belize against Belize Telecom Limited in 2009. On the other hand, the landlord contended it was not an implied term and therefore it could keep the rent. It relied on the older test established by case law on implied terms. First of all, the officious bystander test, the case of Sherlaw and Southern Foundries as long ago as 1926, where one considers whether an officious bystander asked whether both parties want to put some express term in the agreement or not. If he answered yes, it might be appropriate for an implied term to be applied. If he answered no, then it wouldn't be. Or secondly, the business efficacy test in the case of the Moorcock in 1889, an even older case, where the court would imply a term if it was obvious and necessary in the business sense to give proper effect to the contract. The tenants contended that the test had now been changed by the Belize case, which was widely considered to have aligned implied terms with standard interpretation of a contract. In that case, Lord Hoffman restated the test for the existence of an implied term, in short suggesting that a term was simply part of the overall process of interpreting the contract. This requires the court to consider whether the contract term sets out what the term would reasonably be understood to mean when read against the relevant background. The landlord was relying on traditional tests of officious bystander and business efficacy, whilst the tenant contended that a term providing for rent apportionment for the rent should be implied on the grounds it was reasonable and equitable for the landlord to reimburse the tenant for the rent the tenant had paid for a period in which he had no use whatever of the property. The case went up to the Supreme Court. So, second question now. Before we find out what the Supreme Court judges had to say, let's see what you think. Should the court have implied into the contract a term whereby the tenant can claim back the money for rent? If you think the answer is yes, please press A. If you think the answer is no, please press no, and please vote now.
So there, approximately 65% of people said no, and 35% said yes.
Just waiting for the final stragglers to come in. Good to see that there's still some of you not being able to give an answer, but you're sitting on the fence. That's fine. If you said yes, you're in agreement with the High Court and with the Court of Appeal in this case, which found that a term should be implied requiring the landlord to reimburse the tenant for rent paid for the period beyond the period of the break. However, if you said no, you agree with the Supreme Court, which declined to imply such a term. While it would be reasonable and equitable for the landlord to reimburse a significant amount of money to the tenant, the court found that it was not necessary to require such reimbursement to give Mrs. efficacy to the contract. The Supreme Court said that Belize had not changed the law. The traditional test should still be followed. Addressing the formulation in Belize, Lord Neuberger said that the reasonable reader test is not enough. It's also required that the reasonable reader would consider the term to be so obvious as to go without saying or to be absolutely necessary for business efficacy. So it's not enough, it may be reasonable to imply the term into a contract. A term can only be implied if, without the term, the contract would lack commercial or practical coherence. As such, in this case, while it is reasonable to prevent the landlord from gaining a windfall payment, particularly when the tenant had only been scrupulous in complying with its obligations, it cannot be said that the contract lacks commercial or practical coherence without such a term. It is not necessary in the business sense to imply such a term to give efficacy to the contract. The contract still works and makes sense, even if the result doesn't seem very fair. Although the court denied the Belize test was a departure, the outcome of this case is that the Supreme Court has restated the idea of necessity in the business sense in implied terms, in contrast to the freer approach suggested by Belize. This marked a retreat away from a more creative approach to contractual interpretation, in which commercial reasonableness was considered, to a more literal approach. So, following this judgment, the courts have less scope to imply terms into a contract. What practical tips can we take from this? The basic point to note is if you want something in a contract, make sure to write it in. Take care to reflect your intentions explicitly. You don't want to have to rely on the courts to rewrite the contract, since it appears they now have less freedom to imply terms into a contract, even if it's commercially reasonable to do so. If you're involved with property law, it's also worth reading the judgment for what the Supreme Court has to say about break clauses and apportionment, although we don't have time to cover that today specifically.
So the final problem area we're going to focus on today is restrictive covenant clauses and the difficulties that they present. As a quick refresher, a restrictive covenant is a clause which seeks to impose a negative obligation on a party. Usually, it prevents or limits them from doing something. They are commonly used in employment contracts to restrict what an employee can do on leaving employment, or in sale and purchase agreements to protect the goodwill of the business being sold. As a matter of public policy, restrictive covenants are unenforceable as a restraint of trade. The exception to this rule is any restrictive covenant which goes no further than is reasonably necessary to protect the legitimate business interests of the party enforcing the contract. Our third and final case today, Rush Hair Limited against Gibson Forbes, involved a restrictive covenant where one party, upon selling her business, agreed a non-compete and non-poaching clause with the buyer. Miss Gibson Forbes, the seller, owned a hairdressing business which she then sold to Rush Hair, the buyer. In the terms of the SPA, she agreed that she would be subject to two restrictive covenants, both for a period of 2 years from the date of completion of the sale. The first was a non-poaching clause. The seller undertook not to canvass, solicit, entice or employ certain named individuals. The second was a non-compete clause. The seller undertook not, within 2 miles of the buyer's premises in Windsor and Maidenhead, directly or indirectly, to be engaged, concerned, employed or interested in any business which carries on as business similar to that of hairdressing. Before the 2-year period had concluded, the seller incorporated a new company and opened a hairdressing salon in Windsor. The new company employed 3 of the individuals named in the non-poaching clause. The buyer therefore claimed that the seller was in breach of both covenants entered into under the SPA. The seller put forward 2 arguments in defence. First, she argued that there was not a breach of the non-poaching clause because it was a new company and not her which had employed or engaged the individuals. Secondly, the seller argued that both clauses were unenforceable as they went beyond what is reasonably necessary to protect the buyer's legitimate business interests. Let's take the first point and go straight into a question about the non-poaching covenant. The court had to decide whether this clause restricted the seller from indirectly engaging the prohibited employees through the newly incorporated company. The seller argued that the wording of the clause could have, but failed to include a prohibition on employment by a company of which the seller was a director and or shareholder. Therefore, the clause should be construed as containing no such provision. The buyer relied on the case of Guildford Motor Co., which held that the court would not allow a corporate vehicle to be used as a device to get around a valid restrictive covenant. So we'll turn to the question. The seller's new company, and not the seller herself, technically employed the persons specified under the non-poaching clause. So could the seller avoid breaching the restrictive covenant by engaging persons in this indirect way? Again, if you use your voting buttons now. So it looks like about 88% of people have said no, the seller should not be able to hide behind the company in order to evade restrictions, and the remainder, about 12%, have said yes. So the answer is no. As there was surprisingly little authority in this area, the court took the opportunity to expand upon a previous Supreme Court decision in 2013, offering 5 points of useful guidance on restrictive covenants. The court identified the construction of the clause as crucial in determining the first question. The court said that on a strict reading, the non-poaching covenant appeared only to prevent the seller as an individual from soliciting or employing the prohibited individuals, as opposed to through a company. However, the judge considered that the covenant was sufficiently ambiguous that he was required to give it a commercially sensible meaning. He considered that the buyer and seller knew that the seller had traditionally conducted her business through companies, and that they had this in mind when negotiating the SPA. The court therefore deemed that it must have been intended to apply to the seller acting as an individual or by an agent acting for her, including a company. The seller could not evade the negative obligations imposed by the non-poaching clause by engaging employees through a company. As the decision was based on the clause being sufficiently ambiguous to allow interpretation in a commercially sensible way, it's a reminder of the importance of careful drafting of restrictive covenants. So the seller wasn't successful in her first argument. Let's now consider the second argument that the seller advanced. She contended that she was not in breach because the covenants were not enforceable. Her key arguments for this were that the non-poaching covenant was not geographically limited, the duration of both covenants was excessive, and there was inequality of bargaining power between the parties. When considering the covenants were enforceable, the court followed the accepted 3-step approach to interpreting covenants in employment relationships. What does the covenant mean? Does the beneficiary of the covenant have legitimate business interest requiring protection? And does the covenant go no further than is reasonably necessary to protect the legitimate business interests? So we'll go to our final poll today. To remind you of the terms, we've put the basis of the clause in the question on the slides. So do people think that the clauses satisfy the three-stage test or not? Please vote now. So just over half of the people have said yes, and just under half have said no, that the clauses do not satisfy the three-stage test. So the court said yes, the covenants were enforceable. For each of the major points of contention, the court found as follows. Legitimate business interests. The court will take a different approach when considering the legitimate interests that may be protected in the commercial context as opposed to the employer-employee context, being quicker to provide protection in commercial situations. Reasonable necessity. The court referred to the distinction between covenants that are given to an employee to an employer and those given by the seller of a business to a buyer. A buyer has greater freedom in the buyer-seller relationship than an employee has in his relationship. Therefore, in this case, the seller's argument that there was an imbalance in the bargaining power rendering the covenants unenforceable did not succeed. Length of restriction. The 2-year covenants had been upheld in a number of previous cases. The court noted that no covenant has been unenforceable in the commercial context purely because of duration. And in our experience, 2-year covenants in SPAs are not unusual. And lastly, in relation to geographical scope, the 2-mile radius was not considered to be unreasonable.
That concludes the main part of today's webinar, and there's now a little time for anyone to ask any questions which they may have. As I mentioned at the beginning, questions can be submitted by typing them in the chat box. While you're doing that, I'd just like to take the opportunity to remind you this is the second webinar in a series of 4, so please do log into the later webinars where we'll explore concerns or issues that may arise further into a contractual relationship. The next in our life cycle of the contract series takes place on the 23rd of March. There are also other webinars being run by SIP and Wedderburn on a regular basis at the moment, including one more in February discussing the top 5 adjudication cases of 2016 for those you with an interest in this area. If you'd like to find out more about that or any of these webinars, or to catch up on previous series, the link to our web page is on the screen now. So please let us have any questions you might have, and we'll see what we can do to answer them. Thank you.
So the first question we've got is Globe likely to go to the Supreme Court? So I suppose the answer is possibly, because it's a fairly controversial decision. Obviously, if the parties put something in a written contract, then there is an argument that that should be the contract. But the Court of Appeal was fairly clear that it was the kind of ability to make contracts between the parties that allowed it to be varied and allowed all of the terms in the contract to be varied. So it was set out fairly clearly in the Court of Appeal judgment, but yes, it potentially could go to the Supreme Court. I don't know if Guy has any...
Yeah, I mean, the Court was fairly clear on what it was saying. There clearly is some importance in having this area clarified. I think the general view is that it has been clarified by the Court of Appeal, but I don't know of any application at the moment to go further. It's possible that it could go up.
And the second question is, presumably these approaches and rulings would also be persuasive in Scots law. I guess from my accent that one falls to me to argue. Yes, I think the general concepts probably do, although there are fundamental differences between contract law in Scotland and England, consideration being a fairly important one. So from a variation point of view, then I think you would need to kind of look at all the various factors. I think the concepts probably do, but the kind of niche elements of contract law you do need to be careful because they're different.
Okay. There's one more question we've had. Someone has asked, is the Marks and Spencers and BNP Paribas case sector specific for commercial leases? Well, the answer to that question is that obviously the facts of this case are sector specific and the court was dealing with this area of the law, but the Supreme Court did take time specifically to address the fundamental test for implied terms and ruled that Belize did not change the law, and so the officious bystander and business efficacy test will still stand, and that is a wider application than just in sector-specific apportionment of rent cases, so it's certainly lessons to be learnt there in relation to any type of contract changes.
And sorry, we've just had a final question in, what is the reasonable enforcement restrictive covenant period in a normal commercial contract, for example, non-poaching? The suggestion maybe 6 months or 12 months. As I mentioned, we've seen them up to about 2 years where there's specific individuals maybe in a business, and 2 years is relatively common for a normal commercial contract. It's quite kind of contract specific and industry specific in terms of whether it should be 6 months or 12. But it does come down to, ultimately, restrictive covenants are non-enforceable unless they are to protect a legitimate business interest. So if you can argue that the business interests do need protected, so for example, an individual with particular skills that couldn't be protected, or that there couldn't be an equivalent by training or anything else, then obviously that might be able to extend the period. But once you start getting beyond about 2 years, it might be a harder argument to run.
Yeah, I mean, don't forget the sort of practical test that goes to a judge's mind in looking at these cases is to say what he's really trying to do with a restrictive covenant clause is to provide the person who's coming into the business or replacing an employee, if it's an employment case, time to rebuild the business. And he'll ask himself what is realistically necessary for doing that. Certainly anything over 2 years is likely to be excessive, and where there's a business with masses of competition and many other people left in it, or where it's not going to be difficult to build up the business again quite quickly, then a longer period may be regarded as unnecessary. So it's really a question of facts in each case. But 6 months would seem to be pretty safe, although fairly minimal. And I think we would normally argue the 12-month clause would be fine, and we have often fought for and won the argument on 2-year clauses. So I hope that gives people some ideas on where they can go from here. Thank you very much indeed for listening and joining us. I do hope that you'll join us on future occasions, and wish you all good afternoon. Thank you. Bye-bye.